This Sunday on Capitol Connection, Senate Democrats break with Governor Pritzker on the Prisoner Review Board.
It does. It bothers me that they're listening to the Republican rhetoric.
What it means for the Republicans' push to call Democrats soft on crime in this election year. And
we want to make sure that there is network adequacy.
Can Illinois do more to protect patients in pursuit of a doctor? How that law could change. House Democrat Sue Shearer, State Senator Scott Bennett, and State Senator Steve McClure are our guests. It's all coming up on Capitol Connection.
From the Illinois State Capitol Rotunda, Capitol Bureau Chief Mark Maxwell is asking the tough questions. This is Capitol Connection.
Welcome to Capitol Connection. I'm Mark Maxwell reporting from the Illinois State House on this Sunday, March 27. Illinois Senate Republicans scored a bit of a political victory this week in holding up the confirmation of one of Governor Pritzker's appointees to the Prisoner Review Board. Governor Pritzker pushed back at a press conference Wednesday. Here's what he said.
When you've got to keep a parole board going, we got to keep the prisoner review board going, you've got to keep people in place, we have to renominate them or else we lack a quorum.
Governor, does it bother you that even some Democrats in the Senate are a little concerned about some of your nominees on the...
It does. It bothers me that they're listening to the Republican rhetoric, which is, once again, false. They're telling false stories. It's a lot of Facebook fakery about these folks who are nominated. These are people who have served well and honorably in their positions as we've appointed them and deserve to be approved.
They're basically stating facts about the Republicans, about people who they voted for to grant parole. The Democrats are making a decision based on that.
No, but the stories that they're telling are false about the people that are being brought up before the Prisoner Review Board. It's easy to say, this person did something wrong, we ought to keep them in prison, why would you offer parole to somebody? But the reality is that that's exactly the function. Every person that gets brought up before a Prisoner Review Board is somebody who's done something wrong in their lives. Sometimes they committed a violent crime, sometimes a nonviolent crime. But whatever, they get brought up before the parole board when it's appropriate, the Prisoner Review Board. And they have to make decisions, and they can't always make the decision that the Republicans would like to have made. They should make rational decisions based upon the facts before them.
Joining us now is Senate Democrat Scott Bennett, a former prosecutor from Champaign. Joining us now, you've been very close to these issues of the law and justice for your career and at your time here in the Senate.
Correct.
You were one of the Senate Democrats who did not vote along with Governor Pritzker's appointee to the Prisoner Review Board. He'd been there for a while, this appointee. Why not?
Well, in his case, what we're trying to look at, anytime a governor appoints someone to a high position like the Prisoner Review Board, then they have to come before the Senate for confirmation. So we're looking at their background, but we're also looking at their judgment. And in this case, in that particular case, there were some rulings during his time on the Prisoner Review Board that I didn't agree with.
Which ones?
In particular, some of the people that were paroled by the Prisoner Review Board involved some really heinous crimes, people that had murdered their own children and the likes. And so to me, not a good candidate for parole. So if I question your judgment, I'm not going to confirm you from the Senate.
There was also a convicted police officer killer.
Not up for a vote this week, though we're going to have early next week. Yes.
And that's why I point to that, because Republicans are highlighting this as well. Now, this was a different type of release.
Correct.
This is a senior citizen now who was behind bars, who was medically fragile and had a lot of health conditions. Do you take that into consideration at all, or do you still look at the severity of the crime and say, doesn't matter?
Case by case basis. What we need to remember is Illinois phased out parole in the late 1970s. So the only cases coming before the Prisoner Review Board to look for parole are cases that occurred before that date was changed. So yes, you're talking about people that are now up there in age, to be sure, but that alone, to me, doesn't make it a good or bad decision, because just the time has gone by. It doesn't mean it's easier for the victims, doesn't mean the crime wasn't heinous. And so those are things that I'm going to look at. What we have to remember is the parole board is basically second guessing the decisions of the criminal justice system. There was a trial, or a plea, the judge heard all the evidence, heard mitigation or aggravation, gave a sentence. So for a parole board now to go back and say, I think that no matter what that information was then, based on whatever evidence they hear, often what someone did while in custody, that they're going to end the sentence early and let that person out.
There is also a push from some criminal justice reform advocates to bring back parole in Illinois.
Correct.
How do you see that issue?
I personally don't agree with it because for the reasons I just stated. As a
The second guessing of the.
That's exactly right. As a prosecutor, I know how hard it is to get a case to trial, what that puts a family through. In a murder case, often, this is true, often the person who pulls the trigger is younger, right? Well, often the victim is too. And so when you're talking about 30 years later, they spent a long sentence for this crime, maybe now's the time to let them out. I also, I could name the family members of the actual victims that I worked with.
They don't get that chance.
They don't get that chance. And so that's the frustrating part. 30 years later, they're still grieving, and you're basically re-victimizing them all over again when you let them out.
Let's set that prisoner review board and parole issue aside for a moment.
Okay.
And come at the same issue from a different angle, which is that Democrats in this building passed the Safety Act.
Correct.
Just last year. You were one of them.
I was.
And you actually described back then, if we go back, I think even on this program or in some of our news coverage, you described your evolution in thinking on this, specifically around ending cash bail.
Correct.
I asked one of our guests just last week, is there an inherent flaw in the cash bail system that, say, the bail is set at 50 grand or $500,000, and you just happen to be a rich enough person who's also dangerous?
Correct.
You buy your way to freedom before your trial date, where another person who might still be innocent, or maybe they were guilty, just didn't have that deep enough pocket to buy their way to freedom before their conviction. Is that an inherent flaw in the cash bail system that exists today?
Yes. The idea, and here's what it means. You hear people misrepresent what ending cash bail does, and they make it seem like there can't be any, you can't hold anyone in custody awaiting trial. Well, the federal system doesn't have cash bail. What we have to do is just take money out of it, because your point is exactly right. I think of specific examples I had where you had someone with a really good job, or maybe they inherited farmland, or they had a big house, but committed some really heinous crimes. The judge would think they were appreciating the seriousness of the crime by setting $1 million bond or $500,000 bond, which means you post 10% of that. But then we would find someone who would, mortgage their farm, and they would be out the next day, and the witnesses against that person were terrified. The flip side of that is on the low-level crimes, where somebody might be held for weeks in some counties because they can't come up with $100. Money doesn't keep anybody any safer. What they do in the federal system is look by a case-by-case basis. You've got to give information to a judge. You've got to find out, is this person a flight risk? Are they a danger to the witnesses out there? Are they going to commit more offenses? But on a case-by-case basis, we spend a lot of time training these judges, and we pay them a good salary. Let's let them do their jobs and make a case-by-case decision.
You make an interesting point about terrified witnesses. The justice system is sometimes easy to look at from afar and say, bad thing happened, consequence should follow.
Yeah.
But the path to connect those two things is a rocky road.
Correct.
As a prosecutor, you know that well. I guess there's a question about this new ending of cash bail. Starting in January, there will be this line. All the crimes on this side of the line qualify for you to be detained pre-trial. You're locked up until your court date. All the crimes on this side of the line, you're let go without having to pay bail until your trial date. Let me start in this category. Are you worried that without that bond, those people may not come back to court at all?
Well, what I think you do is, again, if you present evidence, you have basically a mini hearing and allow the judge to hear. We did this, I was a prosecutor in McLean County, and we did this system because the jails got so overcrowded because we had such high bonds. The county ended up having to send people to all these neighboring counties because the jail was too full. So they went to a system where they would basically say, let's have a little hearing, let's give information to the judge. It might not be the first hearing, it might be the next day when the attorney has collected the information. And based on that, they look to see, is this person a flight risk or not? If they've lived in a community for 20 years and their kids live there and they've got a good job, they're probably not going to flee over a misdemeanor offense. But on the flip side, if there's someone is a violent felon and they are facing life imprisonment or a 50-year sentence, if a child, for example, testifies against them, no matter how much money they have, they got a pretty good incentive to make sure that that person changes their story or doesn't get to court. That's the real danger we have here. And so, and I had those situations where you had someone, like I said, with a good job that could come up with the money, where I'd have the families calling and say, well, now that we've told finally what happened, my third grader is terrified because the reason they kept these victims quiet for so long is there was a series of threats and intimidation. And now it might all come true because this person can get out tomorrow.
That's a good point you raise as well about witness intimidation that sometimes stymies the pursuit of justice that might protect a victim from further victimization. So, should that crime of intimidating a witness be on this side of the red line, should that crime of intimidating a witness qualify for being locked up until your trial date?
If someone shows a willingness or an interest to intimidate a witness, there's no question they should not be, no matter how much money they have, no matter what the conditions are. I think most judges would say you're going to stay, you're a clear threat to the pursuit of justice here.
But that, correct me if I'm wrong, the current version of the law does not say that. The current version of the law, as I understand it, and I think as the Illinois courts have translated it, in their internal documents, not in some court ruling, they believe that the current Safety Act says if you have intimidated a witness, you would not be locked up pre-trial.
I wouldn't agree with that, and here's one area where I think the legislature has gotten on the wrong path in this regard. When we started looking at the different, what's affecting cash bail and also what the process is for bail, we started listing off crimes. And it starts with, of course, the most serious, but now there's Schedule A and Schedule B under current law today. The problem is, and this is why I say it's unfair to put everybody in one basket. When you were looking at certain crimes, a prosecutor has a lot of discretion how you charge that. One of the ones that's pointed out a lot is a retail theft can largely be charged as a Class A misdemeanor, or it can be charged as a burglary, a Class 2 felony. And you can, depending on what county you're in, almost the exact same fact pattern can go in either category.
But even a burglary, just to play this out, even a burglary, if you are convicted after you had your pre-trial detention or you were let out,
yes, sir.
After your conviction, you might have a really great defense attorney who says that, Your Honor, my client, this is their first offense, they've never been, and maybe that's okay. We're going to put you on probation for 5 years. You did this burglary. You wish you hadn't. You've shown some repentance in the court. We're going to give you on probation. And there are some people who look at the way the law is written that yes, it was a forcible felony, but it qualified for probation. So if we're not going to lock you up at the end of the conviction, why would we put you in jail pre-trial?
Well, you're ignoring everything that happens in between. So, for example, the way the current bond statute is written, that everybody apparently thinks is working well, unless you've actually worked in the criminal justice system. You're looking at factors like what's the likelihood of somebody fleeing, what's the likelihood of someone committing violence, what's the likelihood that you'll get convicted. There's a difference between someone, after they've been charged, saying, I did something I shouldn't do, I want to take responsibility for that, I don't want to put the victim through the trial. I think someone that does that shows remorse, and it shows a lot higher likelihood of rehabilitation. And so in those cases, somebody that looked really, really bad on day one might look a lot better at the end once you get to the sentencing, right?
Even if they're detained pre-trial or they're not.
So in that situation, I'm saying the person that walked in day one, the person that comes out at the end of the conviction might look very different to a judge.
Sure.
The inverse might be true.
Right.
We might have somebody that stretches out the trial, that never takes responsibility, that lies on the stand, regardless of all the evidence that's there, and I've seen that too. And then at a sentencing hearing, the prosecutor proves up a series of other offenses to show this isn't a one-time thing, Judge. This has happened time and again throughout this person's life. And the judge might have said, I didn't think you were a risk out in the community on day one. Now I see it very differently at the end of the trial. So I don't think it's fair to say if you let them out during the pendency of the case, when they're constitutionally presumed innocent, they're going to have to be let out at the end of it. There's a lot more information. The judge that is going to do the sentencing ultimately is going to consider all the information beginning to end when they're making that sentence.
Sometimes, especially in election years, and you see campaign ads coming out and rhetoric sharpening, it's easy to fall prey to that caricature of what justice is and what it isn't. It sounds like, and when I listen to other prosecutors who are trying cases in court today, they say things like, we need better surveillance, better evidence, and better testimony to make our case. You're describing how many pitfalls there are once you go to trial. You think you've got an ironclad case, and sometimes it just falls apart. That suspect goes free. They never go behind bars. What can the Safety Act or some other bill do to better protect witnesses? What can we do to better collect evidence to solve and hopefully prevent future crimes, future victims?
Well, one of the things I think is overlooked a lot about the Safety Act is the body cam language in there. We are able to exactly to your point, it's really easy to second guess a jury when you read about it in the paper or see a reporting of a story. It's a very different thing for those of your viewers that have been on a jury to say, okay, well, now I hear this, I don't know if it's beyond a reasonable doubt. How high is that burden, right? And there's been a recent case in Champaign where the question has been, did someone commit a crime that was in this car? You'll have DNA showing they had access to the car, maybe an eyewitness that said that they were on the scene, and yet the jury still found unanimously that that person wasn't beyond a reasonable doubt guilty. It's a very hard thing to do unless you can. I think we grow up watching CSI and these shows, they want that. They want DNA evidence, they want video, they want a confession. Sometimes that's unavailable. But what we have, when you have body cam footage and other things, you often get someone in the heat of the moment saying, talking about their crime in front of somebody, and it might not be the defendant. It might be a witness that might have seen something, and then when they're excited, they tell you, boy, I can't believe I saw Mark do this. And then later they go, come to think of it, I don't remember who it was. Well, here, you said this right after this might encourage them to be courageous enough to tell the story later on, because there's a lot of intimidation out there for them not to cooperate.
Well, Counselor, I plead the fifth here.
Should have said Mark. Obviously, I didn't mean you.
But to that point, though, you're saying that a body camera might be used to provide evidence. It doesn't just exist to put surveillance on the officer of the law, but also all the people they encounter in the course of their work.
No question. And then let's extend it out further. There's a lot of cases where one of the harder cases to get a conviction on is an aggravated battery of a police officer, for example. Because say you'll have a case where the police officer is 6'5" and clearly works out a lot, and then you'll have someone my size as the assailant, and whether the jury's saying like, I don't think that person could affect that person, or maybe it was an accident, certainly they couldn't hurt them. Anything where we're able to show footage of what exactly happened, maybe the defense attorney says the police officer was acting inappropriately and that person was just acting in self-defense. This is an objective way to let the jury see what the officer saw in that setting. And I think that's something that really gets overlooked. Those that are critics of the safety bill are very quick to say, it's more more people watching or second guessing the action of the officer. I don't see it that way at all. There's an accountability component, to be sure, but I think mostly it's allowing people out there to get an objective view. And here's the example I'll use. Every time there's a police shooting, in my experience, every time there's a police shooting involving a member of the community, before body cams became popular, we would all go to nobody had any evidence, so we would all go back to our respective prejudices. If you back the blue, you believe the officer did the right thing and the other person must have done something they shouldn't have. If you had a bad experience with law enforcement, you'd automatically assume the officer was out to hurt someone. Any kind of body cam footage or objective surveillance video that we're able to see now takes away a lot of that guesswork, and we're able to see which side is telling the truth.
Let's go back to where we started this discussion.
Okay.
About the Senate Democrats' unwillingness to back Governor Pritzker's appointees to the Prisoner Review Board. Isn't that in some way, to some extent, evidence of either political disagreement between Senate Democrats and Illinois Democrats, or that Republicans feel they have Democrats over the barrel on this crime issue?
I don't believe so. What I would say is, one, to assume that you have a general consensus because for every single person of a political party.
I can't remember the last time the Senate didn't confirm one of the governor's appointees to the Parole Board.
That may be true, and I've only been here a few years, but I don't know that we've always had 41 votes. You have 41 Democrats in the Senate, in the state Senate. Often you need 30 to pass. You'll end up with something around 30, 32 votes. Because, what you have to remember is, because the people that are coming in front of the Prisoner Review Board are all people who committed crimes prior to ending parole.
There are no angels coming before the Prisoner Review Board.
That's certainly true, and the easy calls were resolved by Prisoner Review Boards in the 80s and 90s. Those that are still there, and every meeting we're going to have from here to the future, are more and more controversial
cases. Those were longer sentences,
the salacial,
tougher crimes,
details of the cases. So any Prisoner Review Board that's looking at this now is making pretty controversial calls and maybe some questionable ones.
So it's changing the dynamics of how you vote on that issue just because of the nature of the clock, or the nature of the calendar, where we are in the issue. But this is an election year.
It is.
There are Democrats and Republicans in this building who want to see changes to the Safety Act, to draw that red line between crimes that you get out for before your trial and crimes that you get locked up for. They want to see that line drawn a brighter shade of red. They want to make that clear. Can Democrats get enough votes, maybe even some Republican votes, in an election year before the election to get that done?
That's a big question. And I will tell you, I have helped write 2 trailer bills to the Safety Act. And as I said a moment ago, the idea that, well, in the 41 members of the Senate Democratic Caucus, everybody must agree with anything, with all the same thing, is patently false.
Because the GOP message is that Democrats are soft on crime.
That's right. And that's an old tune that gets trotted out election years for decades, right? I mean,
how do you answer that claim? Ending cash bail is soft on crime. To that you say what?
To that I say that attaching a cash amount to any bail does not make anybody any safer. What it does actually is allow violent criminals to be able to get out if they have access to enough money to get themselves out. Instead, what we need to do is give judges the choice to evaluate each case. And if they say, look, you're a real threat here, you're going to go out and continue to commit crimes, I don't care if you do have 30,000 acres of farmland that you could mortgage to get out, you're staying in custody until a jury rules on your case.
Can a judge do that now?
Well, now, under the current law, it says that a person's entitled to reasonable bail. So now, what is, and maybe they can put other conditions on it.
The reason I ask that is because it sounds like you're almost making the argument that changing this, phasing out cash bail, you're making an argument here today that that's getting tougher on some aspects of crime.
I believe it is. In the cases that I had, where I knew the judge was setting a very high bond because they thought this meant there's no way this person's getting out. They didn't anticipate that the witnesses would have to worry about looking over their shoulder during the pendency of the case, and then got those urgent calls from the family members that what you didn't realize is he just inherited this amount of money, he's going to be out tomorrow. I don't think that's what the judge wanted. I don't think that's what anybody watching your program would want. But right now, that's the system we have. And so to take cash out of it, but still allow someone with the experience like a judge to say, no matter how much money you have, if the certain facts are there that give me pause, you're going to remain in custody.
You've been very generous with your time, and I appreciate that. We enjoy having a platform here where we can have these extended interviews up on our website. Before we let you go, I do want to ask you about something else in this building this week. Lawmakers are tackling the Unemployment Insurance Trust Fund. The pandemic blew a $4.5 billion deficit in that fund. Employers had paid into it for so long to set aside enough money to pay out unemployment benefits. And when more than 1 million workers in Illinois were laid off during the pandemic, as you know, that plus the fraud that existed wiped out and depleted that fund. Now we're just going to pay back $2.5 to $2.7 billion of that existing $4.5 billion deficit. That leads us to the next steps. It looks like Illinois is going to have to do one of 3 things: borrow a bunch of money from Wall Street, pay that off over the long term, raise taxes on companies so they kick in more money to unemployment, or slash benefits for unemployed workers. Which of those 3 things do you think we should start with?
Well, I think what we're going to see is a combination of the 3.
All 3.
And you spread out.
Lower benefits are coming to unemployed workers in Illinois.
I believe so, and let me explain that. One of the few areas where you've seen collaboration in this building historically has been the Unemployment Insurance Trust Fund. It's called an agreed bill process.
It's sort of like politically off limits.
It really is, right? You know, the idea of you better not, if you're a Democrat, you can't agree with the other side. What they have done for decades is the business community, the chambers of commerce and the others, sit down with the labor unions and they say, all right, we've got to fill this $1 billion hole. It's going to have a combination of the 2 things. What benefit cuts can we agree to? What premium increases unemployment premium increases can we agree to? And a combination of those things is agreed to that fills that hole. That's what we've had for decades, going back several governors.
Well, that sounds like a lot of bad things. Businesses are going to pay higher taxes. Unemployed workers in the most desperate stretch of their life are going to get less from the state. And we're going to borrow more money. The state's going to go into more debt. All 3.
Wow, you really spin this well, Mark. But the key is this.
Spin?
Well, my point is you're putting a very negative spin on this.
That's a realistic view. I think those are the
fact
facts.
is, I'm not saying in a negative way, but the fact is that when there are problems like a $4.5 billion, whether it's pensions or UI benefit trust fund shortfalls, there's not a lot of good solutions. And so what you have to do instead is come to the table, try to say, all right, businesses shouldn't shoulder all this, the workers shouldn't shoulder all this. Can we find some kind of agreement where we both put a little skin in the game and end up with a solution we can all live with.
Let me ask this question,
Yes.
because the Pritzker administration says they had $3.5 billion left over in federal ARPA dollars. This is money we already got from the federal government. They're only committing in this bill to put 2.7 of it in there, which means there's $800 million left that could close the gap. The state has that money sitting there. I don't know, maybe the Pritzker Budget Office wants to use it some other way. Maybe the General Assembly wants to use it some other way through the appropriations process. I don't know. Why, if you're going to say all those things have to be on the table, businesses paying higher taxes, workers getting less benefits, and Illinois taxpayers borrowing more money from Wall Street, shouldn't that other $800 million also be on the table to go back into this unemployment insurance trust fund and alleviate the pressure on everybody else?
That's one thing that's being argued.
It is.
It is.
Is it on the table?
It is on the table, and that, in fact, the first version had $2 billion of ARPA funds, and the House said we'd like to see more. We'd like the.
In fact, the Senate passed 2.5, and the House said 2.7, so it's moving up.
That's correct. And so in the bill that was passed by the Senate, we used some of that money for other things. You ended up, College Illinois, $200 million went to try to prop that program up, so we're not leaving people who invested in that program in the 90s in a lurch when their kids are now college age. We paid off a lot of money of old health insurance bills. We put about $300 million into extra pension payments. So we are using that responsibly. And I think the key to that is you're seeing a marked difference between how affairs are being dealt with in this state now compared to in previous years, in part because we recognize that our credit ratings, for example, are going to have a huge effect on our children going forward. So we're working really hard to make sure that we've paid back our unpaid bills, that the payment cycle is much quicker than it has been in decades, and that our credit rating is upgraded so that when we do have to bond, as you said, that's one of the three things we'll do to fill up the shortage in the Unemployment Insurance Trust Fund, we're getting a much better insurance rate than if we had the credit ratings of old.
All right. That's Senate Democrat Scott Bennett. Thank you for joining us.
Thank you.
A former prosecutor on the Democratic side. Joining us next is a former prosecutor who's a Senate Republican from Springfield. Steve McClure joins us next. Stick around.